Good afternoon. How's everybody doing? Great to be learning with you at a special time on a Wednesday, Yom Revi'i. Let's light up the darkness. Big excitement. The Guns N' Moses premiere is tonight. I'm on my own. Nia's got her own things she's got to do to get ready. So I'll be scanning the comments at the end of the show to take some questions. But yeah, it's a big night for us and we're really excited. Who's in the house? Yehud in South Carolina, Guy in Ohio, Joe in the Inland Empire, Sharon in New Jersey, Bella in Florida, Capiz in the Philippines. Welcome, Capiz. Shandor in the Bronx, Mazel Tov. Very happy for you to get to celebrate all your hard work. Yehudit, Mazel Tov, dear Nina and Sal, on your movie viewing. I wish I could be there with you, but I will be there in thought. Awesome. Bill in mid-Missouri. Ella's in the house. Marjorie in Georgia. Marie in Freeport. Okay, and God willing, coming soon to a theater near you. That is certainly the goal. Okay. Our daf today is page 110 here in Tractate Bava Metzia, the 22nd volume of the Talmud. Facebook. The 22nd volume of the Talmud. We're working our way through chapter 9, continuing our discussion of Mishna number 9. And Mishna number 9 was all about that one who receives a field for a certain number of years. If it's not enough years, he can't plant flax in it because flax really weakens the soil, nor may he cut limbs from a sycamore. But if he's going to lease it for 7 years or more, then he can plant flax in the first year or take those big branches from the sycamore because presumably there'll be time for them to grow back during his period of tenancy in that field. Okay, we're picking this up near the bottom. It was a very short daf, 109b, so we're about 2/3 of the way down the page. On 109b, our daf today is 110. So the Gemara relates, there was a certain man who mortgaged an orchard to another, i.e. the creditor, right? So somebody is borrowing money and he's putting up the field as collateral, and possibly in this arrangement, the one who extends the loan actually holds the field during the period of the loan. That creates issues, right? So if a Jew is lending money to another Jew, he can hold the field as collateral, but he's not going to be able to take the produce from the field while the loan is outstanding because that would violate ribis, right? That would be usury, prohibited interest in a loan from one Jew to another. So let's see what we've got here. There was a certain man who mortgaged an orchard to another, to the creditor, for 10 years in order that the latter should use the profits gained from the orchard as repayment of the debt. So now the produce of the field is going to pay down the debt. There's not going to be interest because the produce is being used as payments to pay down the principal. But the orchard aged after 5 years and no longer produced quality fruit. The produce from this orchard is not going to be able to pay down the principal of the loan because it's not producing the fruit anymore. Consequently, the only way to proceed was to cut down the trees and sell them as wood. And why wouldn't you? They're not going to produce fruit anymore. What you want to do in that case is cut down the trees, right? So now you've got at least the value of their wood, which presumably could be used to pay down the loan. And now you can plant new trees. It'll take a while, but then that land can become productive again. But in the short run, there's 5 years worth of fruit, let's say, that is still owing on the loan. The trees aren't producing fruit anymore. And so they're saying we're going to cut down the trees, sell them for wood, and we could use that to pay down the loan. Abaye said, the wood is considered as produce of the orchard, and therefore the creditor is entitled to cut them down and sell them. That was the plan. It makes sense. Now that the trees are no longer productive, selling them as wood is going to replace the money that would have come from selling the fruit of the orchard in order to pay down the loan. Now, Abaye is very often in debate and dispute with Rav with Rava. And generally speaking, in disputes between Rava and Abaye, the law follows Rava. And that's going to be the case here. So Abaye said you can do this. Rava said the wood is classified as principal. It's like the land itself, and is therefore viewed as part of the orchard itself. So consequently, the creditor has no rights to the wood itself. But instead, what we do is we cut down those trees because they're not going to produce fruit anymore. We sell the wood, but from the money that we get, we don't give that to the creditor. Rather, that money is used to purchase other land. And then the profits, but the other land is purchased with the profits from the sale of the wood, and the creditor consumes the produce of that other piece of land until the debt is repaid, right? Because what they're doing is replacing principal with principal. Now, debate is, when you cut down these trees, is that considered like produce, replacing the fruit that would have come from those trees? Or is the wood of the trees considered like the trees themselves were part of the land, not the produce? Rava says they were part of the land. So if you can't make this orchard productive, you sell the wood, buy some piece of land, plant something there like wheat, and sell that, and that's what's going to be used to pay off the loan. So the Gemara raises an objection against this from a baraisa that discusses the laws of a mortgage. If the tree dried up or was chopped down, it is forbidden for both the creditor and the debtor to take it for themselves. How should they proceed? It is sold for wood, and land should be purchased with the proceeds. And then he, meaning the creditor, the lender, consumes the produce from that land. And the Gemara clarifies, what? Is it not referring to a dry tree that is similar to one that was chopped down, in that just as the tree was chopped down at its proper time, so too the tree dried at its proper time. And yet, meaning you expect that happens at the end of the life of the tree, and yet the Tana teaches that land should be purchased with the money and the creditor consumes the produce. So apparently the wood is considered part of the principal, not the profits, and this supports Rava's opinion and presents a difficulty to Abaye. So the Gemara rejects this argument. No, the chopped down tree mentioned in the Baraisa is similar to the dry one. Just as that tree dried up before its time, so too this one was chopped down before its time. Since this did not occur naturally, the wood is classified as produce. Had the orchard dried up at the expected time, whatever the life expectancy is of these orchard trees, then its trees would be considered as part of the land. But interesting, like if some kind of, fungus swept into the orchard and the trees, sort of died prematurely, then cutting them down, according to this view, would turn them into produce. Because they would be replacing the produce that you would expect it to harvest from those trees. If they die at the end of their, expected life, then they would be considered like the principal, as Rava says. So the Gemara suggests, come in here a proof to Rava. From a Mishna in Tractate Ketubot 79b, if a woman after her marriage had old vines and olive trees that were bequeathed to her by means of an inheritance, now we're on page 110a, such trees are sold as wood and land is acquired with them, and her husband consumes the produce while the land itself belongs to the wife. Right, so we're looking at another area of the law, the property that a wife brings into a marriage. So we talked about this before, that when a wife brings a field into a marriage, right, it was her possession before she married her husband. So while she and her husband are married, the husband has the right to the produce of that land. Right? He can farm it and he gets the produce, and that's in return for him sustaining his wife. But if they divorce or he dies and she leaves, she takes that land with her. It is her land. The husband only has the rights to the produce while they are married. Now add the wrinkle. While they're already married, she inherits land. Right? No community property. It's not that because they're married, she and her husband get it together. It's her land. So even though she inherited it while she was already married, it's the same idea. The husband has the rights to the produce, and it belongs to her. But in this case, what she inherited was not a piece of land, but rather old vines and olive trees, right? So not a piece of land, but either old vines of a vineyard or olive trees of an olive orchard, and they're not very productive, right? So then what do you do with it? Are you just going to sell it and then it's a certain amount of money of wood and we'll consider it produce and the husband gets that because he has the rights to the produce and she ends up with nothing? No. You sell those old vines or old olive trees, get money from it, buy some small piece of land, and the husband can get the produce from that land. He can farm it and get the produce, but that little piece of land belongs to the wife, and after the marriage ends, she takes it with her. So the Gemara answers that the text of that Baraisa should be amended to say, and they grew old, meaning that the trees were not old when she inherited them, but they aged with the passage of time, and perhaps that's why they would be considered as the principal, so to speak, and when they're sold, they're turned into some other productive land, whereas if they died prematurely, then they would just be sold as produce that the husband could consume. And if you wish, say, did we not already establish that Mishna is referring to a case where the vines or olive trees were bequeathed to her in a different field that did not belong to her? Since in that case she inherited only the trees but not the land itself, they are considered the principal, and consequently the husband taking all of it would consume the principal entirely. Therefore they must be sold as wood with the proceeds used for the purchase of the land. That's how I stated it to you originally, but where I said she only inherited the vines themselves and the trees. But if she got a piece of land with these vines and trees, and they died, then maybe you sell it for wood, and plant something else or get another piece of land because you can't plant in that particular land, but you got to get some land that can produce, right? And if you think about this sort of underlying philosophy to a lot of this, it's very sound advice, right? That when you get, you inherit, especially when you inherit something, let's say it's some money, right? Don't think, oh wow, I just got this big number. I could just put it in the bank, it's some terrible interest rate, take money when I need it, and I won't be so stressed out, and then for a number of years pass by, and then you consume the principal and you have nothing. Anytime that you're in the position of having, some chunk of money, see if you can at least, buy some blue chip stock, if not real estate, that would be ideal, but something that's going to put that money to work, right? So even though you'll have less money in the short run, it won't be consumed. It's going to be producing for you, and you'll be much, much better off in the long run. The Gemara relates, there was a certain mortgage document in which it was written that land was granted to the creditor for an unspecified number of years. And the creditor said it was for 3 years, whereas the debtor said it was for 2 years. Now, while the issue was being adjudicated, the creditor rose up and consumed the produce of the field in the 3rd year. Right? They both agree that the guy has the rights to the produce for at least two of the years. Where they disagree is about the 3rd year. Does the creditor have the right to the produce of that land in the 3rd year or not? So while they're arguing about it, while they're waiting for their case to be heard before a rabbinic court, the creditor just went and seized the produce from that land in the disputed year. Now, which of them, the debtor or the creditor, is deemed credible and accepted? Now, obviously, there's a contract somewhere, but the problem was the contract was not specific. It just said years. And they're arguing about what that meant, whether it was 2 years or 3 years. Now, there are witnesses somewhere, and we're going to have to find them. God willing, there are witnesses. Otherwise, it's just, one person's word versus another. And in the absence of the witnesses, it is just one person's word versus the other. So which one of them are we going to believe? They're both sure that they're right. Maybe one is lying. Maybe one of them is just misremembering it. But that's what we've got, right? So which one of them is deemed credible? Which one should we believe? Rav Yehuda said, the law is that the land remains in its owner's possession. Now, this is the general principle of where there's going to be any kind of a litigation. The one who is seeking to extract damages from the one who is holding the money has the burden of proof, right? So who has the possession? That's what's interesting. The creditor already took the produce. He's taking it from the land of the debtor, right? So before he takes it, if he claims that he has a right to, clearly he's going to have to prove that he has the right to. But he already took it. So now it's the debtor saying he wants to get back the produce that the creditor took. So where are the funds, or where is the produce? In the possession of the creditor. So perhaps we say that the debtor now has the burden of proof, right? So that's what Rav Yehuda is saying. The law is that the land remains in its owner's possession. Therefore, the debtor has the presumptive right to the land, while the creditor who owns the document must provide proof. So as Rav Yehuda says, the creditor has to prove his case because the produce was in the possession of the debtor. But Rav Kahana says the produce remains in the possession of the one who consumed it. The creditor already took it. Therefore, we accept the claim of the creditor, and the debtor has to prove it. In the absence of being able to prove it, it's going to stay with the creditor. So the Gemara states, and the law, the halacha, is in accordance with the opinion of Rav Kahana, who said that the produce remains in the possession of the one who consumed it. And the Gemara asks, but don't we maintain that the halacha is in accordance with the opinion of Rav Nachman, who said that with regard to uncertainty concerning a rental during the extra month of a leap year, that the land remains in its owner's possession and he has the rights to that month. So these two rulings appear to contradict each other. And the Gemara answers, there it is a matter that will not be revealed because it is impossible to clarify the uncertainty concerning whether the extra month is included or not. By contrast, here it is a matter that will be revealed, as the witnesses who signed the document may eventually reveal what it stated. Right? They signed the document didn't state how many years the creditor had a right to, but they heard it, even if it wasn't written down, so they could reveal what the actual agreement was. Since it's possible to reveal it, it's not an uncertainty that's going to remain an uncertainty. It's an uncertainty that can be solved. Therefore, we do not trouble the court to convene twice, before the witnesses come and after. Therefore, the produce should remain in the possession of the one who has it, meaning the creditor who consumed it, until the matter is resolved, meaning that the debtor now has the burden of proof. If he can't bring the proof, he's not going to get back that produce that the creditor took. Now, the Gemara analyzes another case involving mortgaged land. The creditor says that the mortgage was for 5 years. He has the right to consume the produce for 5 years in order to pay down the loan, while the debtor who owned the land says it was for 3. So the debtor said to the creditor, give me your document so that we can see what is written there. The creditor said to him, I lost the document. Convenient, right? Rav Yehuda said, the creditor is deemed credible and accepted in this case. Now the reasoning is interesting. It's because it's a case of migo, the Talmudic principle of migo. Migo means because he could have spoken an argument that's much stronger than the one he offered. Therefore, since he sort of doesn't make the strongest argument that he could make, it must be because he's telling the truth. How so? Rav Yehuda said, the creditor is deemed credible and accepted in this case because of migo. He could have made a more advantageous claim. How so? As the mortgage document is missing, and even according to the claim of the debtor, the creditor could be in control of the land for 3 years. And when somebody controls a piece of land for 3 years, they establish a presumptive ownership over that land. So the creditor could have said, no, I wasn't the mortgager of holding this land as the collateral to pay off the loan. I bought this piece of land. It's my land. He could have said that, and the debtor wouldn't have been able to prove otherwise because this guy's been sitting on the piece of land for 3 years, and then it would be difficult to remove him in the absence of some document, and the debtor doesn't have that document. Since the creditor said, no, it was mortgaged to me, I didn't buy it, I've been in control of it for 3 years, but I have 2 more years of the rights to this produce, since he didn't make the more advantageous argument, it must be that he's telling the truth, so we believe him. Rav Papa said to Rav Ashi, Rav Zevid and Rav Avira do not hold of this opinion of Rav Yehuda. They don't apply migo in this situation. Why? Since the document stands ready for collecting the debt, the creditor would certainly have been careful with regard to it. Since he wants to ensure that his money is returned, it is unlikely that the debtor actually lost the promissory note. Rather, he is merely hiding this loan document because he thinks, I will consume the produce of the field for 2 extra years. Right? He's hiding it for his own advantage so that he can get 2 extra years. So we don't believe him, we believe the debtor. Now the Gemara analyzes Rav Yehuda, who said we do believe him. Ravina said to Rav Ashi, if that is so, that Rav Yehuda is correct, then with regard to the mortgage, according to the custom that is practiced in Sura, a city in Babylonia, in which they write the following. Upon the completion of these years of the mortgage, this land shall leave the creditor's possession and return to its owner without the debtor paying any money. In a case where the creditor hid the mortgage document and said that the land was purchased by me, so too is it possible that he is deemed credible? Would the sages institute a matter that might cause a loss? And Rav Ashi said to him, there in the mortgages of Surah, the sages instituted for the landowner, meaning the debtor, right, who's mortgaging his land to the creditor, that the landowner the debtor pays the land taxes and digs the trenches for the irrigation of the field. And in this manner, his ownership is preserved and established. No one would think that the creditor who has moved in to consume the produce for a certain number of years to pay off the loan, that he actually bought it and now owns it, because the borrower, who is the actual owner, continues to be involved with that land, and that, is something that's witnessed by the town, so they see he never sold the land. And Ravina asked further, with regard to land that has no need for trenches and for which the owner does not pay taxes, then what could he have done? And Rav Ashi said to him, he should have protested before the 3 years needed for presumptive status had passed by announcing that the land was his. And Ravina again inquires, well, if he did not protest, what is the law? And Rav Ashi replied, well, in that case, he caused his own loss by failing to take the necessary precautions. The Gemara discusses another case. If a sharecropper says, I descended to the field for half the produce, right? A sharecropper as opposed to the tenant farmer. The tenant farmer rents the land for a fixed sum, and then he can keep whatever he gets out of the land as long as he pays the fixed sum. The sharecropper keeps a percentage for himself and gives a percentage to the landowner, and they agree on the split at the outset, although it's generally, right, done in accordance with the custom of that region. So now we're talking about a sharecropper. If a sharecropper says, I descended to the field for half the produce, as this was the agreement that we made, but the homeowner says, no, I sent you down into that land for 1/3, right? So the sharecropper says, our agreement was we split the produce half and half. The owner says, the agreement we made was that you get 1/3 and I, the landowner, get 2/3. So who is deemed credible and his claim is consequently accepted? Who do we believe? So Rav Yehuda says the homeowner, the landowner, is deemed credible, and his claim is consequently accepted. While Rav Nachman says all matters are in accordance with the regional custom. As the terms of their agreement are unknown, this sharecropper should have the same status as other sharecroppers in that location. And they understood from the above discussion that these two sages do not disagree, but were referring to different cases. This one, Rav Nachman stated his ruling with regard to a location where the sharecropper takes half, in which case the sharecropper is believed. While that one, Rabbi Yehuda stated his ruling with regard to a location where the sharecropper takes a third, in which case the homeowner is believed. Either way, we go with the custom, and then we believe the one whose claim is according to the custom. Rab Mari, the son of the daughter of Shmuel, said to them, this is what Abaye said. They even disagree with regard to a location where the sharecropper usually takes half. In that case, Rabbi Yehuda said that here too the homeowner is deemed credible and his claim is consequently accepted. As if he wants to lie, he could say, the other guy is not a sharecropper at all, but merely my hired worker who received a stipulated wage, or he's my gleaner who performs occasional work for me, but has no prearranged share of the crop at all. Yeah, he was working the land, but we didn't have a sharecropping arrangement. Since he could have made that more advantageous claim and he doesn't, clearly Rav Yehuda is applying the principle of migo. So the Gemara addresses another issue. If a field was on lien for a loan and the debtor died, okay, so borrowed money, then the creditor, went in and occupied the land and he's taking the produce until the loan is paid off. And during that period, the borrower dies. Then what? So the orphans who inherited the field say, well, we enhanced the land after we inherited it. And therefore, the creditor does not have a right to the value of that enhancement. And the creditor says, you didn't enhance it, your father enhanced it. And I am entitled to the land as it is upon that, right? And I'm entitled to the land as it is. Right? So the disagreement is who did the enhancing? Was it the father before he died, and therefore the creditor has the right to that to pay off the principal? Or was it the orphans who enhanced it after their father died, in which case the creditor doesn't have a right to that enhancement, that enhancement value? So who do we believe? So the orphans say, we enhanced the land after we inherited it, and therefore the creditor does not have the right to the value of the enhancement. And the creditor says, your father enhanced it, and I am entitled to the land as it is. So, upon whom does the burden of proof fall? Now we're on 110b. So Rabbi Hanina thought to say that the land remains in the orphan's possession, as they are currently in control of it. And therefore the responsibility falls upon the creditor to bring proof. And a certain elder said to them, this is what Rabbi Yochanan says, the responsibility falls upon the orphans to bring proof. And what is the reason for this? Since this land stands ready for collection, it is considered as though it has already been collected and is in the creditor's possession. Consequently, the responsibility falls upon the orphans to bring the proof. Abaye said, we learn a similar halacha in the Mishna, Bava Basra 24b, as well, with regard to a tree planted adjacent to a city. Such a tree must be chopped down in any event, regardless of what preceded what. So if the city preceded the tree, the owner is not entitled to compensation. But if the tree was there first, he receives payment for the tree. If it is uncertain whether this one was first or that one was first, the owner of the tree cuts it down and the people of the city do not give money to the owner. Apparently, since this tree is standing to be chopped down, as it is chopped down regardless of whether it or the town was there first, we say to the owner of the tree, you must bring proof to support your claim that the tree was there before the town, and only then may you take its value, although the tree is currently in his possession and has not yet been cut down. Because what matters is which one was there first. So even though it's in his possession, the dispositive issue isn't in whose possession it is, it's which was there first. So too, with regard to this document recording the lien on the land, since it is ready for collection, it is considered as though it has been collected, and the responsibility falls upon the orphans to bring the proof. Now, in the case where the orphans brought proof that they indeed enhanced the land, so Rabbi Hanina thought to say, when we remove them by giving them part of the land equivalent to the value of their enhancement. And the Gemara comments, but that is not so, as we remove them by paying them with money, as derived from a statement of Rav Nachman, as Rav Nachman says that Shmuel says in 3 cases, the court appraises the enhanced value for the parties involved in enhancing a field, and they are paid in money rather than being given a portion of the property. And these are they. The first is a firstborn son who makes payment to an ordinary, i.e. non-firstborn son. This is a case where 2 sons, one firstborn and the other not, inherit a field from their father. Before it is divided, they both work and enhance the field. When the time comes to divide the field, the firstborn son, who receives a double portion, must pay his brother for the enhancement that the latter contributed to the former's portion. And this payment is given in money rather than land. And the second case is that of a payment taken by a creditor, or the payment of a marriage contract by someone who is obligated to reimburse orphans, i.e. a creditor or widow who collects land from the orphans of the deceased debtor or husband, respectively. He or she must pay the orphans for any enhancements that they made after their father's death, and this payment is also given in money rather than land. And the third case is that of a creditor who is obligated to purchasers, i.e. a creditor who collects the debt from lands that were sold by the debtor. He pays money to the purchaser for the enhancements that they generated, but he does not pay him in land. We don't break up the field, rather we use money to settle this liability from one to the other. Ravina said to Rav Ashi, "Is this to say that Shmuel maintains that a creditor must pay the value of the enhancement to the buyers?" Right? And just remember, keep in mind, enhancement means that somebody rented or for some other reason had the rights to a field for a while, even though he didn't own it, and then he enhanced it, right? He did work on that field that increased its value, improved it and increased its value. So when he leaves, the landowner has to reimburse him, at least to some extent, for the value of that enhancement that the guy who was renting the land did to the land while he was there. So Ravina said to Rav Ashi, "Is this to say that Shmuel maintains that a creditor must pay the value of the enhancement to the buyers? And what type of enhancement is there that is given to a buyer according to Shmuel? But doesn't Shmuel say a creditor collects even the enhancement, not only the land itself? And if you would say that this is not difficult, as here it is referring to enhancement that is so great that it reaches the shoulders, meaning the one who was occupying the land planted a crop and the crop has matured, and what it means to the shoulders means that it stands ready to be harvested, but for whatever reason the tenant now has to leave before the harvest, right? That's the enhancement, and we want the guy who spent the whole growing season tending to the crop, he should benefit from that crop even though he has to leave right before it is harvested. That when land reverts to the landowner, he owes the former tenant for that crop. That's what it means, an enhancement that reaches the shoulders. Whereas there it is referring to enhancement that does not reach the shoulders. Then it is still difficult. But aren't there incidents every day where Shmuel would collect everything on behalf of a creditor, even enhancement that reaches the shoulders? And the Gemara responds, it is not difficult. This is referring to a case where the debtor owed him the amount of the value of the land and the enhancement combined, and therefore the creditor does not leave the buyers with anything. Whereas, right, why they're buyers and creditors, right? Because the debtor is the landowner, right? He owes money to the creditor, so the creditor is consuming the produce to pay off that loan. But the debtor owns the land, and he may wish to sell the land, not to the creditor, but to the new purchaser of the land. So you can see that now the purchaser of the land and the creditor of that produce of the landowner, who has a right to produce, they have competing interests, and that's what we're working out. Now, since he has taken more than the sum to which he is entitled, he pays the buyers for the improvement, right? So if the creditor took more than what he's entitled to, he owes these buyers because they're stepping in to get a piece of land, and they negotiated to buy it outright, maybe with what's on it as well. The creditor can only take what he's entitled to, and then the rest of it goes to the new owners, the purchaser. Now the Gemara asks, and if he did not owe him, meaning if the landowner / debtor did not owe the creditor the amount of the value of the land plus the enhancement, it was stated that the creditor gives the buyer, right, the new buyer, money and removes him from the land, right, because the creditor, as we learned yesterday, has a initial right to that piece of land because he already has an ownership interest in it. He's like a neighbor. And so if he wants to buy the land, he has a right to buy the land, and he can push that buyer away. And if the buyer has already paid money, the creditor can give him the money that he paid and then take him off the land and take it for him. And the creditor can now become the new owner, be both the creditor and the buyer. Now, this works out well according to the one who says that even if the buyer has money, he cannot remove the creditor by paying him his debt in cash, as the creditor has the right to claim the land, to purchase the land. So according to this opinion, it works well. But according to the one who says that if the buyer has money, he may remove the creditor by paying him cash. Okay, fine, you're owed money. Here's the money for your debt. Now I'm going to buy the land and have it free and clear. But according to that, why? Because then we're not treating the creditor as a neighbor. At least not one with a great enough priority that he automatically gets to buy the land. So according to this view, let him say to the other as follows: if I had money prepared, I would remove you from the entire land. Now that I do not have money equal to the value of the entire land, since you must repay me for the enhancement, at least give me a plot of earth in my land corresponding to the amount of the value of my enhancement. Okay, I can't buy all the property, but I did enhance it, so pay me for that, but rather than pay me with money, pay me with a small portion of the land. And the Gemara responds, here we are dealing with a case where the debtor set aside this land as designated repayment, apoteki, for the creditor, as he said to him, you shall be able to collect from only this land, but no other. Consequently, the creditor wants to take the entire land as his lien applies only to this field. And if it turns out that he has other claims, he will be unable to collect them from elsewhere. And that concludes our discussion of Mishnah number 9 here in chapter 9. Now, Mishnah 10. In the case of one who receives a field from another to cultivate for one sabbatical cycle, one Shemitah cycle of 7 years, which ends in the Shemitah year, and he pays 700 dinars for that, right? So the deal was made at the end of the previous sabbatical year, right? The sabbatical year, the Shemitah year, where we don't plant the crops. This is in ancient Israel when the temple was standing and the Shemitah cycle was in full effect. So every 7 years, the fields would go fallow, right? Now, somebody's going to rent a field, and he's going to rent it for 7 years. And in year 1 is going to be the first year after the Shemitah year. So he says 7 years, right? And he's going to pay 700 dinars for it. So the question is, the following Shemitah year, the 7th year of the cycle, is that included in the deal? Well, what did they agree to? One Shemitah cycle. So that's 7 years, which means 6 years of planting and 1 year that the land is resting. And that's the deal. And you'll see how the next case is different. Right, so one who receives a field from another to cultivate, right? He's renting it or sharecropping it for one sabbatical cycle of 7 years, culminating in the sabbatical year, and the agreement is for 700 dinars. So then the sabbatical year, the 7th year, is included in this tally, despite the fact that he's unable to work the land during that year. But if he received the land from him to cultivate for 7 years, right? The agreement in the first case was for a sabbatical cycle. The language of the agreement in the second case is for 7 years. So then the sabbatical year is not included in the tally, and the renter may keep the field for an additional year to take the place of the sabbatical year during which he could not work the land. So if they agree, I'll rent it for 7 years, then he's actually going to get it for 8, which is going to include 1 year where the land lies fallow. But if they said, I will rent it for one sabbatical cycle, then he only gets 7 years. Even though one of those years he can't plant. Now the Tana addresses a different issue. The halacha, the law of the payment of workers. A day laborer collects his wages from his employer all night following his work shift, right? A day worker, you're supposed to pay him at the end of the day. Until when is the limit that you can pay him? So if he works all day, then that night you have to pay him his wages. And you can pay him anytime during that night until dawn the next day. And then it's too late. You have violated the Torah commandment of don't withhold wages from a worker. So a day laborer collects his wages from his employer all night following his work shift. A night laborer collects his wages all the following day, right? Meaning you can pay him anytime during the following day. While an hourly laborer collects his wages all night and all day. With regard to a weekly laborer, a monthly laborer, a yearly laborer, or a laborer for a sabbatical cycle of 7 years. If he left upon the completion of his work in the day, he collects his wages all day. If he left at night, he collects his wages all night and all day. That's Mishnah 10. Now the Gemara. The sages taught, from where is it derived concerning a day laborer that he collects his wages all night? Meaning that the employer has the entire night after the day that the guy worked to pay those wages. And the verse states, Leviticus 19:13, the wages of a hired laborer shall not remain with you all night until the morning. And this indicates that he must pay him by the morning. And he has therefore not transgressed the prohibition of delaying payment of wages until that time. And from where is it derived concerning a night laborer that he collects his wages all during the next day? As it is stated, on the same day you shall give him his wages. Deuteronomy 24:15. And the Gemara asks, but why not say the opposite? I.e., that a night laborer should be paid at night, while a day laborer receives his wages during the day. And the Gemara responds, the obligation to pay a person's wage is incurred only at the end of the period for which he was hired. Since he's working all day, you can't pay him during the day. It's, there's no time left. Day ended. So now you have to pay him during the following night. The sages taught from the indication of that which is stated in the verse, the wages of a hired laborer shall not remain with you all night, lo talin. Do I not know that this means until the morning, as this is the meaning of remain with you all night, talin. So why must the verse state until the morning? It teaches that he transgresses the prohibition of withholding payment only until the first morning alone, but does not transgress this prohibition another time for any further delay. It's not that he incurs a new sin each day that he doesn't pay. It's that he has transgressed the prohibition once he's late, but he doesn't keep incurring new penalties, as it were. He doesn't keep committing new transgressions. The Gemara asks, from that point forward, what is the law? And Rav said, although one no longer transgresses the prohibition of delaying payment of wages, he's already done that. We don't add additional transgressions. Nevertheless, one violates the prohibition of do not delay by delaying his wages. So there is a further transgression each day that he's late. Rav Yosef said, what is the verse from which it is derived? Proverbs 3:28. Do not say to your neighbor, go and come again, and tomorrow I will give when you have it with you. If it is in your power to pay a laborer, pay him on time. The sages taught concerning one who says to another, go out and hire workers for me. So both of them do not violate the prohibition of delaying payment of wages if they fail to pay immediately. This one, the employer, he is exempt because he's not the one who hired the workers. Strictly speaking, they're not his hired workers. They're the hired workers of the one who hired them. Now we're on page 111a, getting a little head start on tomorrow's daf. And that one, the middleman, is exempt because his work is not performed for him. So the Gemara asks, well, what are the circumstances of this case? If the middleman said to them, your wages are incumbent upon me, well, then his wages are indeed upon him. He's the one who transgresses if they're not paid on time. As it is taught in a Baraisa with regard to one who hires a laborer to perform work in his own field, and the employer inadvertently showed the laborer a field belonging to another in which he should work, so the employer must give the laborer his full wages. And in addition, the employer goes back and takes from the actual owner of the field in which the laborer worked the value of the benefit that the owner received from the laborer. The employer is entitled to claim from the owner of the field the profit that the owner gained from the work, but not the entire wages of the laborer. And this indicates that one who says your wage is incumbent upon me is responsible to pay those wages. And the Gemara explains, well, it was still necessary to say this because where the middleman said to them, the obligation to pay your wages is upon the employer, in which case they share responsibility for the payment, and neither violates the prohibition because neither is solely responsible. And the Gemara relates, Yehuda bar Marimar would say to his attendant, go hire workers for me and say to them, your wages are upon the employer. Yehuda bar Marimar instructed the attendant to do this in order to avoid violating the prohibition of delaying payment of wages. Marimar and Marzutra would hire workers for each other for the same reason. It's not like they were trying to get away with not paying the workers. They were just protecting themselves in case something happened and the payment was late. They didn't want to violate this prohibition. Rabba bar Rav Huna said, those market... I'm almost done. Questions or comments, please get them in now. Rabba bar Rav Huna said, those marketplace workers of Surah do not violate the prohibition by Torah law of delaying payment of wages in the event they do not pay their employees immediately. And this is because everyone knows that they rely on the market day to earn their money. And the employees are aware that they will not be paid on the same day that they worked. But he certainly violates the prohibition by rabbinic law of do not delay if he withholds payment any later than the market day, right? So we see that there's, some common sense here. Particularly you say, well, wait a minute, we don't always pay our employees like each day after they finish their job. Okay, we have an agreement with them that they're going to get paid, weekly or monthly or whatever it is. So that's fine. You can make that kind of arrangement, especially that's the custom where we now live, and that's the custom in almost all jobs. But, if you have just like a one-off job and you bring somebody in to do it, yeah, you should expect to pay them that day. Okay. Let me take some questions. Okay, I'm scanning the comments because Nina is not available. Josette, shalom and best wishes for you and Nina's movie premiere tonight. Thank you both for all you do and teach me. Love from the Rocky Mountains of Colorado. Thank you so much, Josette. Joe, in Redlands, a nearby city, they pulled up the old city-owned orchards of navel oranges because as the trees aged, the fruit became too small to sell for a profit. That's just what we're talking about. They then replaced the trees with new ones and are waiting for the trees to become profitable again, right? So it's going to be laying low for quite a while. And that might be a case where you would hope that maybe, when they pulled up the old trees, that, maybe there was enough profit from the wood that they could buy some small piece of land, and farm that and get some kind of income while they're waiting for the new trees to start producing fruit again. Yehuda, Toda Rabbah for this meaningful shir, despite your very important movie premiere just a few hours away. Thank you so much, Yehudis. Nancy said, sorry, I hope for wisdom more than legal reasoning. And Sharon says, the wisdom comes from the process of the adjudication. In the reasoning lies morality. Like so often, right, we have to train ourselves to pierce through, like what is going on in the legal reasoning that is, teaching us the underlying principle so that we can go in the ways of God when, we're applying God's law in various situations. And that's it for the comments. Okay, my friends, so great to be learning with you on a Wednesday special time. Wish us luck. May everything go smoothly, please God, with all the technical aspects of the screening and any other aspects. And with God's help, we'll report back tomorrow and tell you a little bit about how it went. And we should be learning tomorrow at our regular time, 6 p.m. Pacific on Thursday night. All the best.